Hello there, this is Clifford from Clifford Odhiambo and Company Advocates. We are located at the Junior Place along Lenana Road in Hurlingham. Honorable Justice Ohugo, in one of his recent judgments, had warned that if courts are going to allow defaulters to avoid paying their just debts, then all banks will be crippled and soon be driven out of business, and no serious investor will want to bring in their capital into a country whose courts are a haven for defaulters. In this weekly case law review, we look at a recent ruling of the High Court in the case of Tusker Mattresses Limited versus Equity Bank Kenya Limited and another. The citation of this case is Nairobi Milimani High Court Commercial and Tax Division Insolvency Petition number E18 of 2020. The ruling of this case was delivered by Honorable Justice D.S. Majanja on the 29th of March, and it attempts to answer a simple question: is a bank's statutory power of sale subject to insolvency proceedings or a court-imposed moratorium? The applicant in this case is the subject of an ongoing insolvency proceeding, and for this reason we will not delve into the merits or the demerits of the ongoing insolvency proceeding, as this will be sub judice. Instead, we will solely focus on the ruling of the court, which has now been published and is available to the public for its consumption. Owing to its legal consequences, this ruling will not only interest banks, credit cooperatives, SACCOs, and other microfinance institutions, but also companies which are shielded by a court-imposed moratorium. The brief background of this ruling is that sometime in the beginning of this year, the applicant had filed an application seeking temporary injunctive relief against the bank meant to restrain it from exercising its statutory power of sale over its property situated in the Nairobi Central Business District. The applicant supplicated to the court that should it fail to grant it the prayers sought, then it was likely to lose its property, which was earmarked for sale in a scheduled public auction. The other argument advanced in the application is that the same court had put in force a moratorium, staying all and any legal proceedings and actions against it. The same orders had the effect of forestalling the enforcement of any judgment, decree, or orders against the company pending hearing and termination of the insolvency proceedings. The company argued that despite this, the bank had proceeded to instruct a firm of auctioneers to proceed with the sale of its property. And just like in the celebrated case of Giela versus Casman Brown, the company had argued that it had demonstrated with enough evidence that it had an arguable case with a likelihood of success, and it was going to suffer irreparable damage which could not be compensated by way of damages should the orders not be granted. And lastly, that if the court was in doubt, then the balance of convenience tilted in its favor. The applicant also lamented to the court that since the bank had not undertaken a valuation of the subject property before proceeding with the scheduled auction, there was a likelihood that the same would be sold at an undervalued price. This would be the same as sanctioning the bank to proceed and breach its statutory duty of care that it owed the company. Under Section 97, subsection 1 and 2 of the Land Act, a chargee in exercising his statutory power of sale of a charged property is required to obtain the best price reasonably obtainable at the time of sale. And before exercising his statutory power of sale, a chargee is required to ensure that a forced sale valuation is undertaken by a valuer. The applicant argued that his financial position was redeemable and proceeded to remind the court of the purpose of insolvency proceedings as captured under Section 3, subsection 1 of the Insolvency Act, which requires courts to have at the back of their mind at all times that they ought to enable companies continue to operate as going concerns so that they be able to ultimately meet their financial obligations to their creditors in full, or at least to the satisfaction of those creditors, and that the purpose of insolvency proceedings is to achieve a better outcome for all the creditors as a whole instead of liquidating a company. This argument seemed to resonate well with other judicial pronouncements on the subject, where the courts have held that in determining conflicting interests among creditors, a court will protect the claims of various stakeholders such that there is no risk to enforce individual claims to the detriment of other creditors. The bank in rejoinder cited the good on principles of corporate insolvency law 5th edition in submitting that assets that are subject to a charge or a mortgage or any other security interest do not belong to a company and as such are not subject to insolvency proceedings. All a company has at that particular stage is the right to redemption. It also argued that as a secured creditor, it was entitled to exercise its rights under the security document, and that its statutory power of sale was not subject to insolvency proceedings commenced against the applicant by any of its creditors. Wittingly, the bank argued that what will be subject to the insolvency proceedings will be the surplus from the sale of the property, and that whereas Section 430 of the Insolvency Act prohibited against the attachment, sale, or distress of assets belonging to a company under liquidation, the same did not prohibit a chargee from exercising his statutory power of sale. In countering the argument that the applicant will suffer irreparable loss, the bank argued that once the company charged its property, the same became a commodity for sale upon default. In any event, the bank, being a Tier 1 bank, will certainly not be unable to settle any damages that may be awarded by the court. In the end, Justice Majanja, in delivering the ruling of the court, held that whereas there were earlier orders staying any and all legal proceedings and actions against the applicant, and further that there were orders staying the enforcement of any judgment, decree, or orders against the applicant, the same did not apply to the bank's statutory power of sale over the secured property. The learned judge was also of the view that the intention of granting the moratorium orders was to ensure equality among the unsecured creditors as a class. This was in line with the objectives of the insolvency law that creditors of a class ought to be treated equally. The key finding of the court was that as a secured creditor, a bank was entitled to exercise its statutory power of sale without recourse to a court exercising insolvency jurisdiction, as such powers are not subject to insolvency proceedings. This case may be a low blow to those who subscribe to the school of thought that a company ought to be insulated from aggressive creditors who may cause a run of its assets. From the ruling we have just analyzed, the take-home is that there are certain debts that a company must pay even if it has been ring-fenced by a moratorium. Debts and liabilities arising out of instruments involving financial institutions remain payable unless otherwise agreed upon with the lender. We at Clifford Odhiambo and Company Advocates have the requisite knowledge and expertise to assist companies and financial institutions alike which are staring at similar disputes or have similar disputes ongoing. For further assistance, kindly get in touch with us. Well, that's it for now. See you again next time.